Hello and welcome to the President's Podcast right here on the record with the Ohio Senate. The views the news excludes. I'm your host, John Fortney, the Director of Communication for the Senate Republicans in the Senate, the Majority Caucus in the Ohio Senate. Joining us this week on the President's Podcast, State Senator Rob McColley from the 1st District in Northwest Ohio. Good to have you back on.
Thanks for having me.
Really interesting week this week with Senate session and the amendment to House Bill 114 of Senate Bill 215, which was sponsored by you and I believe Senator Gavarone, which addressed foreign contributions in issue campaigns in Ohio. Talk a little bit about the amendment and the process of House Bill 114 that also included an amendment to put Joe Biden on the ballot in Ohio.
Yeah, so, we have two issues that are very important regarding the upcoming presidential election. The first that we'll talk about, I guess, is what's been termed as the Biden ballot fix, where the Democrat National Committee decided not to look at various states' election laws prior to scheduling their convention. And as a result, their convention is actually going to occur after the filing deadline to be on the ballot in the state of Ohio, or rather after the time in which a candidate would need to be certified by the Democrat National Committee in order to be on the ballot. And so the Attorney General has stated, at least a temporary law would need to be put in place to extend that deadline to allow President Biden to appear on the ballot. While in my case, and I would imagine every member of our caucus's case, we know we're not going to be voting for President Biden. And while personally I feel that the election between President Biden and President Trump will go much the same as it did 4 years ago in the state of Ohio, we thought it was important that Ohioans be given the opportunity to have a choice in the matter, and that we weren't going to engage in the same lawfare that the Democrats are trying to engage in across the country.
Colorado.
Colorado and other places trying to keep President Trump off the ballot. So that was the first issue that needed to be dealt with. The second issue that's really a clear and present threat to our election system in the state of Ohio is the rampant foreign election interference that's happening right now in the state of Ohio. And it's in the form of foreign contributions that are being made by foreign nationals in our elections. And so the Ohio Elections Commission, actually state law, already says that foreign election contributions from foreign nationals are already illegal. It's expressly made clear in the code that they're already illegal for candidate elections. The Ohio Elections Commission has already stated that that also applies to issue campaigns. But nevertheless, there are groups out there like the 1630 Fund that we've talked about before that are putting massive amounts of money in the state of Ohio trying to inject their foreign influence into our elections. On a bipartisan basis, we should all agree that this is offensive to our sensibilities, that our elections should not be funded by foreign interests, and it should be funded by United States citizens, particularly Ohioans, who have an interest in what happens here, as opposed to the election interference from foreigners that we're seeing right now. And so the Senate Bill 215 would have made it expressly clear that that type of foreign election interference through the massive amounts of money that's coming in is illegal in the state of Ohio. To put it in perspective, 1630 Fund alone, just in 2023, in the August and November election, spent over $13 million in the state of Ohio. $13 million. There have been statewide offices that have not had that much money spent in those races. And so we should all realize and acknowledge, that is a very clear and present threat to our elections going forward and the confidence and the integrity of our elections that the people view it with in the state of Ohio. And again, I'll make clear what I made clear on the floor. I don't know that it would have made a difference in either August or November in the election results. Maybe they would have been closer, maybe not. But everybody should agree on a bipartisan basis that we don't want this type of foreign meddling in our election.
And you would think that every Democrat would understand that as well, since Ohio law already prohibits, outlaws foreign contributions going to a campaign for a candidate. So all 7 of them in the Senate voted against it. In fact, some of the rhetoric from the floor from Senator DeBora was like, this is the worst kind of politics, I think is what he said, which doesn't make any sense whatsoever. To me, it means that they don't want to vote for anything that might preclude their ability to get backing for a constitutional takeover of Ohio government that comes from foreign campaign donors or contributions coming from outside of the United States. They must really rely on this money. It's the only thing I could think of when I was sitting there listening to the floor speeches against this bill.
Absolutely. And look, in the grand scheme of things, let's be clear, this money, even though astounding in its scope, is only a fraction of the dark money that's coming in on behalf of the Democrats in these ballot initiatives. They'll always make an issue out of the money that comes in from individuals on our side who may also be very wealthy in their own right, but at least they're putting their names on the campaign finance report. At least they're United States citizens who have been willing to put their names out there as engaging in their First Amendment protected speech of donating to these types of campaigns. The same courtesy does not happen when foreigners invest in these types of campaigns, and also when they do so through the veil of dark money.
Yeah, I would suggest we're not talking about old school, what a lot of people might think of who are my age, Democrat type style leadership in politics. We're talking about far left, progressive left, idealists from outside of the United States trying to take over the state constitution with radical ideology.
Absolutely. So actually the name behind this, as we've discussed before on the podcast, is a Swiss billionaire named Hans-Jörg Wyss. The man has donated well over $200 million to the 1630 fund of his own personal fortune in just the last 8 years or so. And he has even said in a book that's been written by his sister, I believe, that he seeks to recreate the United States Constitution and the United States form of government in his own image that he feels like it should be created in. And I feel like that's an alarming thing that, again, on a bipartisan basis, we should all agree that we should not allow this type of foreign meddling in our elections to reshape our government as we know.
And by the way, the Senate passed Senate Bill 215, back in March, late February? And it has not been assigned to a committee in the House yet.
Correct. It has not even been assigned to a committee to have hearings.
So this seems like it makes perfect sense that you would want to ban foreign influence, foreign meddling in Ohio elections in the form of campaign donations from outside the United States that are targeting ballot initiatives, which we will continue to see, as we talked about clear back in the summertime, a revolving door of attacks on Ohio's Constitution. And once it's in the Constitution, that's a higher level of law above Ohio Revised Code. So you just can't pass a new bill and then change the law. If it's in Constitution, that's the way it is, right? Unless repealed by the voters. In the House, there was a competing bill, Senate Bill 92, that was going to be stripped and then amended, I believe, with just let's put Joe Biden on the ballot to make it simple, right? And all the stories around that, all the narrative around that, even from Republican leadership in the House was, it's a done deal, everybody supports this. And apparently not too many people supported that in the House because it was what we call informally passed, which means what?
It means, in essence, they skip over it on the calendar. They don't take a vote on it. It means they pass over it and it maintains its place on the calendar so they can come back and vote on it either later that session date or at a later date. It's also a signal that generally they're either waiting for some event to occur, like receiving a message from the other chamber, or they don't have the votes for it. And so I would say it's more than likely that there was not the requisite support in order to pass that bill.
House Bill 114, along with the Senate Bill 215 amendment into it, we sent that over to the House very early in our sessions. So they could have voted on that as well. So I guess where are we then with this whole idea of Biden on the ballot? Because you know what the narrative from the left is. The left is Republicans are trying to keep Joe Biden off the ballot, which is not the case whatsoever. And if you read a column from a couple weeks ago on the record, or you just go to ohiosenate.gov, click on news, and you'll see On the Record, our online newsroom, a great column from Terry Johnson that points out, well, who is really trying to keep whom off the ballot? Seems like Colorado and the Supreme Court there trying to keep Donald Trump off the ballot. It seems like all the trials that are going on around, the country, there's been a very strategic effort to keep Donald Trump off the ballot in many blue states. That is not the case in the state of Ohio when it comes to Joe Biden. So what is the next step, if there is anything?
Well, I think it's clear the Senate fulfilled its duties and its obligation to try and allow Ohioans to have that choice because, frankly, I agree with you. I think it's disgusting that these other states are trying to engage in lawfare, exceeding their constitutional authority to try to keep President Trump off the ballot. And I think it's indicative, really, of where they think this election is likely to be headed due to the disastrous policies and the disastrous term that we've seen from a President Biden administration. But where do we go next? Like I said, the Senate has passed what I think was a very reasonable proposal that would have addressed two very important issues, including the foreign election interference and the foreign meddling through those contributions. And I believe that there was a strong amount of people, if not a strong majority, within the House, from what I've been told, that wanted to support that bill. And so we can speculate as to why it was not brought up for a vote, but at least I can say it was likely, at least from what I was told, had the votes had it been brought up. So what do we do next? In all likelihood, this is probably headed to a legal battle. I suspect the court system may very well rule that President Biden can have his name put on the ballot in the state of Ohio. But it shouldn't have gotten to that point. It really shouldn't have.
Right. Unless the House would decide at its next session to go ahead and take up House Bill 114 that we amended 215 into on the Senate side and then pass that, because obviously they couldn't pass anything related to putting Joe Biden on the ballot this past week. One of the other things that we are seeing, the dark money, specifically Senate Bill 215 addressing, is this new redistricting initiative that attacks the will of the voter from 2015 and 2018, when Ohio voters passed two constitutional amendments reforming the redistricting process in Ohio, and it passed by more than 70% of the vote. Now, what most likely will be on the ballot, if the millions of dollars that are being spent gathering signatures for their petition drive is certified, will be this little gem right here. And we love to talk about this on the record with the Ohio Senate on the President's Podcast, because this is citizens, not politicians. And this is a flow chart that was posted by Ohio Politics Guru on X. Don't know who Guru is, but thanks for doing the work. Apparently, he is also gathering signatures for part of their petition drive. But there's 56 to 60 steps on this, okay? This is more complex than trying to get on the Ohio Lottery show or putting together furniture without a blueprint. This truly, if I could boil it down, this means let the court draw the map. Let special masters draw the map. When it's supposed to be a citizen panel, and this is going to be the fair way to do it, but this is an initiative to break apart compact districts to get progressive left candidates selected.
I think it's even beyond that. I don't even think it's let the court draw the map. I think it's let the specially appointed, unelected folks through this complicated process draw the map, and then let it turn into a Lawyers Full Employment Act, because the way it is written is so ambiguous and not clear at all that it's going to wind up getting litigated, and we're going to wind up in the same mess. The reason I believe it's so complicated is because of the gymnastics it had to do to really, in some ways, not only remove the legislature from the conversation of how these districts are drawn, but also remove all other branches of government as to how these districts are drawn, including the court system. If you read it, there are only certain sections of the amendment that would even be subject to judicial review. And so this group of independently appointed people that really is anything but, by the way it's drawn, are really going to have almost unchecked authority to do what they want to do. We've seen this in other states. Michigan had the same thing happen. The initial map in Michigan was actually ruled illegal under the Voter Rights Act because it racially gerrymandered and racially discriminated, because the whole amendment is set up to achieve political outcomes above all else. And so if you were sick of the fact, before our redistricting amendment passed in the past decade, if you were sick of the fact that there would be large cities that were just broken up into way too many districts in a hub and spoke model, which we eliminated through the redistricting amendment that was passed in the last decade, and which we don't have in the state of Ohio anymore. Those communities are kept together. But if you were sick of that, that's coming back. The snake on the lake that everybody was upset about, that's coming back, because that's actually the only way that it is statistically possible for you to draw a strong, heavily favored Democrat district with the city of Toledo in it, is to do the snake on the lake due to the population of both. You can draw a very competitive district with the city of Toledo in it, but you can't draw a heavily favored Democrat district. This amendment requires that there be Democrat districts drawn in such circumstances, and so the snake on the lake is coming back. So for as much as the people who are supporting this amendment bemoaned the snake on the lake for a decade, the reality is they're advocating for it to be put right back in the maps going forward.
Last week we had Auditor Faber and President Huffman on talking about this, and President Huffman talked about how it was the League of Women Voters who supported both the 2015 redistricting initiative for the General Assembly and the 2018 one for the congressional map. And now they're back to basically what we had before all of that. In fact, Jen Miller, and I wanted to get your reaction to this. I got their reaction to it last week. But she was on a recent Columbus Dispatch podcast called Then What Happened? So Jen Miller is the head of what I like to call now the League of Liberal Disinformation. But she said the following. She said, but at the end of the day, there was no explicit ability for the Supreme Court to draw their own maps or get their own special mapping masters. We have that now. And it's like you said one thing in 2015 and 2018, and now you're taking the exact opposite position. This is a highly partisan organization. This is no longer an organization about fair elections and making sure people understand how elections operate and voter registration. They're all in on the progressive left, the 1630 left, the foreign dark money influence left. I mean, this really has hypocrisy written all over it.
It does, and quite frankly, there was no reason or no way for the Supreme Court to appoint special masters, is because they were expressly prohibited under the amendment that was approved by 70+% of the voters in the last decade, because there was an acknowledgement that this function belongs with the commission going forward to draw these maps. And we don't want the judiciary coming in and exceeding the scope of its ordinary judicial review and de facto taking over the process. Now, let's keep in mind, there was Supreme Court precedent in the North Carolina redistricting case last year that actually said, as it concerns congressional maps, that the Supreme Courts of these various states are limited solely to judicial review of the constitutional provisions. The Supreme Courts themselves cannot draw the maps. And so it remains to be seen whether those provisions, as they concern the drawing of congressional districts, would even pass constitutional muster under the United States Constitution.
Interesting, too, when you talk about when the North Carolina ruling came down from the U.S. Supreme Court, how quickly the NDRC, a lot of the other special interests that repetitively sued because they were conducting maps through lawfare, they were getting what they wanted from the 4-3 majority from the then different makeup of the Ohio Supreme Court under the former Chief Justice, Maureen O'Connor, who is currently running the Citizens Not So-Called Politicians organization, their campaign, but how quickly those groups walked away from the process. Oh, no, this is good enough now, because they knew that they were about to lose if they continued to sue and might get a map that was not so much in their favor.
Exactly. The North Carolina case came out and said, as it concerns congressional maps, the courts are limited to ordinary judicial review. They cannot impose duties beyond what the Constitution of their respective states requires either. And so they knew after our case was taken up on cert and that the order of the Ohio Supreme Court was vacated and the case was remanded back to the Ohio Supreme Court, thereby making our maps constitutional because there was no order saying that they were not at that point because the United States Supreme Court removed it. They knew that that the previous Supreme Court in the state of Ohio had overstepped its boundaries and that they would not survive scrutiny at the United States Supreme Court for what had happened.
Let's talk about the idea of 2015 and 2018 and what those rules do. What we saw happen under the 2015 Ohio Redistricting Commission process in October, in the fall of last year, 2023, when you just focused on the process and all of the other special interest groups were told to go jump in the lake, take a hike, and it was just left up to the Republicans and Democrats and other elected officials at the state level, you got a 7-0 unanimous vote for the most compact, bipartisan unanimous maps in this history of Ohio.
Absolutely, and it worked. What the voters put in place in 2015 worked. It worked exactly how it was supposed to. When the interference from outside sources, particularly allied groups out of D.C. who were working and meddling on behalf of the Democrats, when they were forced out of the room because the Supreme Court no longer was going to allow them to determine what the outcome was going to be before the case even got in front of the court. When they were forced out of the room, it forced all of us in the room to have a good faith discussion and negotiation where we had legitimate cost-benefit discussions and trade-offs. And so the Republicans gave up ground, the Democrats gained ground. There was an acknowledgement that due to the fact that we cannot split certain communities and we cannot split counties certain ways, there was an acknowledgement that this is what the map, given Ohio's political geography, is going to look like. And it's a fair map. And it passed 7-0 with bipartisan unanimous support, the way it was intended to work. But nevertheless, the same groups that opposed it and meddled the last time and caused all the chaos are back because they want it to be exclusively and completely about political outcomes and the splitting of communities be completely disregarded throughout the process.
They call that representational fairness, but really there's a simple term for it. That's called gerrymandering.
It is the textbook definition of gerrymandering, drawing a district solely for the political outcome that it's going to provide.
Why would, this is how I've always looked at this. We're talking about inherently a political process to begin with, the drawing of political districts for the Ohio General Assembly, that the voters send that person who they elect to represent them, right? So why would we want the judicial branch of government to make these decisions for a co-equal branch of government that the voters decide who to send there in the first place? Isn't this really a process of the legislative branch? And then the way we have it now with the Redistricting Commission, you still have the Secretary of State and the State Auditor and the Governor's Office part of that. So that depending on if you have an R or a D in that office, that can also influence the process some. And you could still have unanimous bipartisan maps. But why would we ever want the judiciary making those decisions? And I would say the same thing if I was a progressive leftist. Why would I want the Republican Supreme Court or a Republican majority of the United States Supreme Court, whatever it may be, why would I want the judicial branch deciding anything for the legislative branch?
It really separates from the traditional norms and true role of what the judiciary should be. The judiciary at both the federal and the state level is limited to judicial review, calling balls and strikes on these constitutional issues and not imposing its own will outside of simply saying, this is what the law says, this is what the Constitution says, or it's not what the law or Constitution says in these cases of interpretation. There's no reason that the judicial branch should then be empowered to overtake functions that are not delegated to it traditionally in the constitutional norms of our society, country, or state. And it's really, in a way, in some fashion, to really take this out of the hands of the traditional entities and institutions that have been put in place to deal with this. And frankly, even though there are good checks and balances in our current system that require minority support in order to pass a 10-year map, that require us to abide by certain provisions of the Constitution to make sure we don't split certain communities solely for a political advantage. Even though all those checks and balances are in place, and they worked extremely well with the maps we approved with a unanimous bipartisan 7-0 vote, it was not good enough, because all of this is really about is political power for the people who are backing it.
Candidates and campaigns and issues matter. Would you agree? I mean, because of the seats that Republicans hold in the Senate, I believe half of them have a Democrat lean to them. I'd have to look it back up, but at one point I did know this. I was thinking that of the seats, more than half have a little bit of a Democrat percentage lean to them, just based on how the district is drawn. But yet you have a Republican, for example, Senator Coonsey, right, and more of a Democratic leaning districts. Candidates, campaigns, and issues matter, do they not? But if this passes, maybe they won't matter. So
that's absolutely true. It's about 8 of our 26 districts or so that have a Democrat lean. They're districts that should have a Democrat in them on paper, where Democrats come in with an advantage in those districts that they should be able to maintain. But we have been really good at running campaigns with solid candidates who run on really positive messages, and they outperform the index because the voters of those districts look at them, look at the binary choice in front of them and say, I would rather have that individual, regardless of their party, representing us than that individual representing us. And we've won elections, we've put in the work, and we've had good people in those races. And so really this is groups trying to remedy the fact that the left has not been successful at recruiting attractive candidates for those races. They've not been successful at running good campaigns, and they have not been successful at conveying a message for how they would change Ohio for the better. Let's face it, Ohio is a center-right state at the moment, and people are going to, for the most part, want to see it go center-right, even in some of these districts that may be slightly left. There's a willingness to go and support a candidate who might be Republican, who's representative of that district, especially in cases where the Democrat candidate is simply unsuitable to win that election in that district.
Wanted to get your thoughts, too, on what we start to see more and more often. I call it bench shopping, where a city, usually a major metropolitan area, doesn't like something that the Ohio General Assembly has done. Case in point, House Bill 68, protecting minors from radical sex change surgeries and hormone treatments. Children, minors, little kids, but also, for example, Columbus, there's a judge who put a stay through, I think it's the end of May, on the law that we passed that said no, local governments may not have their own laws regarding vaping products and, for example, menthol cigarettes that the city of Columbus had originally banned. We said you can't do that. It's a tax issue. But yet you shop around enough, you find a judge who will put a stay on anything. What's your thoughts on that? And is that something that the legislature should examine, about whether something like that should just be appealed directly to the state Supreme Court?
Well, I think it's certainly worth examining. So Ohio's system is different from the federal system in that when there is an order that puts in place a stay or an injunction, in the federal system, you can appeal that up immediately. And so if a district court says we're going to enjoin the effectiveness, or we're going to put a stay on the effectiveness of this law, you can then go to the appellate court, and then you can then go to the United States Supreme Court, because there's an acknowledgement that these types of stays have been put in place. They're oftentimes going to be affecting negatively large groups of people, and we need to get clarity quickly as to whether those laws should go into place. A judge especially at a trial court level that does not represent the entire country at the federal level, or in the case of Ohio, has only been elected by people in one county, should not, in effect, have the governor's veto pen when they are making these types of decisions. And Ohio's law effectively says that the trial court level can basically stop a law from going into effect, even though that judge has only been elected in Cuyahoga, Franklin, or Hamilton County. That judge can stop a law from going into effect for the entire state in some circumstances, and then they can wait and really drag their feet in allowing that case to come to its conclusion, oftentimes before that ruling can be appealed up to the appellate court level, which is in a lot of cases been elected by a wider swath of people, or the Ohio Supreme Court, which has been elected, of course, by all Ohioans. And so I do think there's a reason and good logic that we should look at trying to more closely align with the federal system to say when those wide sweeping rulings are made at the trial court level, there should be an immediate right of appeal up to the appellate court and then up to the Ohio Supreme Court.
I wanted to briefly come back to election law, sort of along the same lines of Senate Bill 215, voter ID law that I know that you supported along with Senator Gavarone. Do you think that is needed now more than ever, especially what we were seeing with illegal migrants crossing the border, or as during Senator Serino's border security forum that you can still watch on our social media? Just go to ohiosenate.gov and you'll be able to see it on the record. Just click on news. It was made very clear by the Attorney General at the border security forum that some people go through the process, they declare asylum at the border, they're said, well, we'll get you a court date, and then they're just released into the ether, never to be seen or heard from again, except maybe at their local ballot box with potentially no valid identification. Now, the left seems to think that if you ask for voter ID, if you make someone prove that who they say they are, that they actually are, well, that's racist. That's wrong. Based on what's happening at the border, is election security even more of a priority than it was?
I think we need to be focused on all sorts of measures that give people more confidence, not less, in our election system going forward. Voter ID is absolutely one of those issues. It polls at around 80% in the country, meaning it is an issue that is staunchly and strongly supported by a bipartisan majority across all different demographics in our country and in our state. And so for them to say we shouldn't have voter ID, you kind of, I believe, have to look at a little bit beneath that and say, why would they not want us to have voter ID? And it's not for the reasons that they're stating, given the fact that that type of support is only enjoyed across all demographics when you see numbers that are that high.
Well, it's part of the foreign campaign, foreign election interference that we were just talking about. These foreign dollars that come in from outside the United States to try to influence Ohio's Constitution, with a $40 or $50 million spent on some ballot initiative that changes the law at the constitutional level in Ohio. And running the government, legislating through constitutional amendment, is a horrible way to run the government. Would you agree?
Oh, absolutely. So, issue one, not to relitigate the past, issue one back in August that sought to raise the threshold for constitutional approval, as much as people wanted to say it was all about abortion, I can tell you as the sponsor of the resolution that put it on the ballot, it wasn't all about abortion. It was about what we're seeing right now. The
revolving door of this.
The massive influx of dark money, and in many cases and in large sums, foreign dark money that is coming into our state to fundamentally remake it from the outside in. And I think that's a problem. People should all be opposed to the weaponization of the process that we're seeing right now by foreign actors, and that's why we sought to do what we wanted to do with 215 and ban that type of practice.
Last point that I'll have you comment on today. I have been, and I think a lot of people have been, stunned, shocked, far more than surprised by what they are seeing on college campuses these days regarding the protests, and not even the First Amendment right to protest and free speech. But the takeover of secure areas on college campuses in support of a terror organization that killed dozens and dozens of people in a surprise attack in Israel, Hamas did, back on October 7th. It seems to me that Ohio State, although we've seen from the progressive left a lot of, rhetoric and attacks and calls and demands for the president to step down, it seems that the new president there, Ted Carter, had it right.
I will say this, as an Ohio State alum, as a third-generation Ohio State alum, and somebody who cares deeply about my alma mater, I'm very happy Ted Carter is the president of Ohio State. And it's a challenging situation. I get it. Ted Carter is a decorated veteran, somebody who has a decorated military service history. He believes in our Constitution and what it stands for. And so he's not against free speech. He was very clear that there are time, place, and manner restrictions that are allowed under our Constitution, provided they're viewpoint neutral, to say, this is finals week. We owe an obligation to our students to make sure that they have the ability to study and prepare for finals so they can be successful in what is ultimately the goal in going to college, that being getting an education and preparing yourself for the next stage in your life. He was very clear about that. And so when they violated those time, place, and manner restrictions, that's when he had no choice but to step in for the interest of the rest of the students on campus, to make sure that they had a positive experience going into finals, setting themselves up for the best opportunity at success. And let's keep in mind, you can even look at the police reports. Most of the people who were arrested at these protests were not even Ohio State students. In many cases, from talking with law enforcement, many of them were agitators from outside, in some cases, even the state of Ohio.
I wonder who's paying them?
Yeah.
By foreign election interference donors, maybe? You wonder.
It's amazing that the tents in all of these encampments across the country were all remarkably similar. It's almost as if somebody made a bulk order for all these tents and had them delivered in cooperation and collaboration with outside groups.
I got a big chuckle out of last week when I saw the student leader from Columbia University come out and tell the press that we're hungry and the university has a duty to feed us as we have taken over this building. These people wouldn't last 5 minutes at boot camp. It reminds me of that great line from the series Justified. I don't know if you've ever seen it, but U.S. Deputy Marshal Raylan Givens says, outlaw life is hard. You just wonder where these kids get these ideas that this is a good thing, and then complain about having no food, and then maybe even complain about getting kicked out of college.
It's even more troubling when you see it on a private college campus, because they are not even bound by the same restrictions as a public university. And so Columbia, the second these people started demonstrating, could have gone in and removed these people immediately. As could any other college campus that's a private university, not a publicly funded one. Yet they allowed this type of stuff to go on. They allowed massive vandalism to happen to some of their facilities. And I think it's because of a failure of leadership at the top, where they don't have somebody like Ted Carter who's willing to say, we'll allow you to do and exercise what you believe you want to accomplish here, but not at the expense of the university in the form of physical damage, and not at the expense of the rest of the student body.
State Senator Rob McColley, well spoken as always. Thanks for your time.
Thank you, John.
Thanks for tuning in, and we'll see you soon.